Hello, and welcome back to GovDoc News. No opinions, just facts and summaries of government documents. You take it from there. We are back with a Supreme Court opinion in the case Gutierrez v. Saenz. All right, we are going back to 1998, and Ruben Gutierrez, who was convicted of capital murder in Texas for the killing of Escolastica Harrison and sentenced to death. Since 2010, Gutierrez has sought DNA testing of crime scene as evidence, claiming it would prove he was not in Harrison's home during the murder. Texas's Article 64 allows DNA testing if a convicted person shows they would not have been convicted with exculpatory or innocence-proving results. Here meaning that DNA testing would be allowed if Gutierrez could show he would not have been convicted if these results were present at the first trial. So, naturally, Gutierrez files these requests. 2010, denied. 2019, denied. The Texas courts ruled that the absence of his DNA would not prove his innocence in the underlying crime, only potentially his ineligibility for the death penalty. So, Gutierrez filed a federal lawsuit under 42 U.S.C. Section 1983 against District Attorney Louise Saenz, arguing that Texas's DNA testing procedures violated his due process rights by preventing access to evidence needed for his habeas petition. The district court granted declaratory. This is important. That means that there's no action required in their order. They're just clarifying something. So the district court got the case and they granted declaratory relief, finding it unfair that Texas allows habeas petitions but restricts DNA testing to proving innocence of crime. So that was appealed to the Fifth Circuit, who vacated the district court's ruling that Gutierrez lacked standing as declaratory judgment was unlikely to make the prosecutor allow testing. So basically, no action in a declaratory relief means that you're not going to be able to make the prosecutor allow testing. Then the Supreme Court stepped up and says, the Fifth Circuit, you are wrong. They reversed the Fifth Circuit ruling, holding that Gutierrez has standing, as a favorable ruling would remove the unconstitutional barrier to DNA testing, consistent with the case Reed v. Gertz in 2023. So, the case has been remanded for further proceedings with the guidance that the lawsuit can go forward with Gutierrez's current standing. All right, Kaimo, keep your mind open, do your own research, form your own opinion. See you in a little bit.